Is it legal to practice animal sacrifice in the USA? Short answer, yes. But you might be surprised to hear that it took the Supreme Court to decide this, and that this court case continues to shape religious freedom law to this day. We always think animal sacrifice to be a ritual only done by ancient societies, but that's actually not true. Lots of modern religions still practice animal sacrifice, including adherents of Hinduism and most notably for the Supreme Court case, the religion Santeria. Santeria is an African Caribbean religion that originated from when the Yoruba people of West Africa were forced over to the New World through the European slave trade. There in the Caribbean, they practiced their ancestral religion alongside Catholicism, eventually leading to the modern religion where you can still see influence from both Catholicism and Yoruba religion. Today, tens of thousands of people practice Santeria, mostly in Cuba, Puerto Rico, the Dominican Republic, and the USA. And animal sacrifice is a fundamental ritual to Santerians, usually slaughtering farm animals like sheep, goats, roosters, and chickens by cutting the carotid artery, which they argue is a very humane way to kill the creature. It is believed that killing the animals feeds the orishas, the spirits in the Santerian religion, who consume the animal's life force, or ashe, which is represented by its blood. The meat of the animal itself is consumed by the people in an act of communion with the orishas. The scholar Joseph M. Murphy at Georgetown University describes it best in his book Santeria, African Spirits in America. The theory behind all Santerian sacrifice is that the orishas consume the invisible ashe of the sacrifices that is instilled in, or better, liberated from them through consecration. The ashe of the sacrifices is consumed invisibly through the blood of the animal and animal sacrifices, which is sprinkled or poured on the fundamental symbols of the orishas. Now, this might sound pretty straightforward, but this ritual actually caused a minor panic in the South Florida city of Hialeah in the 1980s. In 1987, a group of Santerians, the Church of Lukumi Babalu Aye, sought to open up a cultural center and house of worship in the city of Hialeah. The city council called an emergency meeting and passed a resolution banning any unnecessary killing of animals, carrying a fine of up to $500 or imprisonment for up to 60 days. District courts upheld this decision, saying that, yeah, animal sacrifice is animal cruelty and a risk to public health. But the Church of Lukumi Babalu Aye did not like this ruling. Animal sacrifice is a big deal to Santeria, so they sent it all the way up to the Supreme Court, where the city ordinance was struck down unanimously, 9-0. Justice Kennedy, who still sits on the Supreme Court today, delivered the opinion. Under the Free Exercise Clause, a law that burdens religious practice need not be justified by a compelling governmental interest if it is neutral and of general applicability. The city ordinance's text and operation demonstrate that they are not neutral, but have as their object the suppression of Santeria's central element, animal sacrifice. Justice Kennedy's opinion was that this city ordinance was specifically tailored to target Santerian ritual slaughter. It wasn't a neutral or generally applied law. That is to say, other types of animal killing were allowed, just not religious sacrifice. He goes on to say, legislators may not devise mechanisms, overt or disguised, designed to persecute or oppress a religion or its practices. The laws here in question were enacted contrary to these constitutional principles, and they are void. So the Church of Lukumi Babalu Aye won, and you can still visit their website to this day. And it seems that this is settled law, too. In 2009, a similar case came before a district judge in Texas. A Santerian priest was being outlawed from practicing animal sacrifice, but citing this precedent from the Supreme Court, the court sided with the priest. But before you go do something rash, the slaughtering of animals still falls under the Humane Slaughter Act of 1958, which has all sorts of stipulations on how to kill an animal humanely. So don't go thinking that this Supreme Court case just gives you free rein to do whatever you want to animals. The slaughtering of animals is highly regulated, and I'm in no way condoning animal sacrifice, just so that's clear. I don't bring up this court case so you can go ritually slaughter your own goats and chickens. I bring this up because it continues to be cited as a precedent in religious freedom law to this day, including Donald Trump's so-called Muslim ban. In early 2017, President Donald Trump issued a ban of anyone traveling from 7 predominantly Muslim countries, a travel ban that was soon struck down by the United States Court of Appeals as discrimination against Muslims. The 9th District actually cited Lukumi Babalu Aye versus Hialeah as precedent. This all goes to show how complicated and messy religious freedom law can be. But that's to be expected. Religion itself is complicated and messy, so we should expect the laws to be too. I'm expecting a lot more religious freedom debates to be happening in the coming years, so when they happen, keep an eye out for the Supreme Court case. It might be cited as a precedent. But what do you think? Is animal sacrifice animal cruelty, or is it the constitutional right of every American? If you'd like to debate with the Supreme Court, leave your comments below, but try to be respectful. Religious freedom debates can get a little heated, and I don't want you to start a fight. As always, thanks for watching and subscribing, and I'll see you next time. My mission here at Religion for Breakfast is to promote the study of religion from a neutral academic perspective. If you'd like to support me in this mission, I invite you to go over to patreon.com/religionforbreakfast and donate a few dollars a month. It goes a long way to help keeping this show running. Thank you, and stay tuned for the next video.